Okay, ladies and gentlemen, we're about to start our briefing as soon as our colleagues from Newsroom, in fact, you'll join us on the road. Welcome to the press briefing of the Ministry of Justice and Correctional Services. We are joined today by the National Director of Public Prosecutions in South Africa, Ms. Shamila Batoy, on my far right. We are also joined by the Central Authority on matters of mutual assistance and extradition. That's the Director General of the Department of Justice and Constitutional Development, Advocate Mashabani, and of course the Minister of Justice, Mr. Ronald Lamula. I'll now hand over to Minister Ronald Lamula to give us an outline of what the matters are before us today. Thereafter, Minister Lamula will be immediately followed by the National Director of Public Prosecutions, Ms. Shamila Batoy, who will also give a few remarks. Then we'll take a couple of questions from there. Thank you. Minister.
Thank you very much, Crispin, who is the spokesperson of the Ministry of Justice and the Correctional Services. The Central Authority, which is the Director General for the Department of Justice and Constitutional Development, the National Director of Public Prosecutions, Advocate Shamila Batoy, gentlemen from the media, and the public at large. The purpose of this media briefing is to provide members of the public with a status update on priority mutual legal assistance and extradition requests to and from the Republic of South Africa. The Department of Justice and Constitutional Development's International Relations Legal Unit is currently attending to various matters involving mutual legal assistance in criminal matters and extradition requests, both from and to South Africa. And this is what is referred to as the Central Authority under the Director General. We deem it appropriate to be transparent to South Africans through the media and provide an update on the status of high-profile cases which involve foreign nationals in South Africa, foreign nationals of interest to South African law enforcement agencies, and South African nationals in foreign jurisdictions across the globe. Extradition is the conventional process in which a person is surrendered by one state to another based on a treaty or committee or a bilateral arrangement between the two sovereign states. A request for extradition made by a sovereign state is usually initiated because the individual sought by that state is charged with a crime but not yet tried, or tried and convicted, but the accused escaped and is presently in the territory of the requested state. The purpose of extradition is to make sure that the accused or convicted persons, criminals, are surrendered from one country to another for the purpose of criminal prosecution or serving the sentence which was imposed upon conviction. This process enhances the fight against transnational crimes and strengthens mutual cooperation between states in fighting and preventing and suppressing international and domestic criminality. Mutual legal assistance in criminal matters is a process by which states seek and help in gathering evidence for use in criminal cases. We live in an era of globalization, where certain groups and individuals are conducting trade and businesses by various means and channels. At unprecedented manner, most of the crimes have become cross-border in nature, and thus the obligations on part of the states to extradite has gained enough significance and value over the years. Despite the advent of globalization, different nations have unique legal traditions and legal systems which require different procedures and requirements for obtaining evidence during an investigation and using that same type of evidence at a trial. These procedural and evidential rules can prove to be a challenge within the realm of mutual legal assistance and extradition. The Department of Justice and Constitutional Development, through its Director General, is designated as a central authority for the Republic of South Africa. The Central Authority facilitates the implementation and operations of an international treaty in public and private international law, This includes receiving and processing requests of extraditions and mutual legal assistance. And as a result, the department deals with a variety of matters for both mutual and legal assistance, a number of them. But for the purpose of today, we have a few that we want to update on. And I'm going to start with the first one for the day. The extradition request from South Africa to foreign states. The matter relating to the Gupta Brothers, the United Arab Emirates, Mr. Atul Kumar Gupta and Mr. Rajesh Kumar Gupta, commonly known as the Gupta Brothers, are accused persons in two criminal matters. The first matter is already before the High Court of South Africa, Free State Division, Bloemfontein, as versus Mr. MMP Tabete and 17 others. Park Road, case number 9712 of 2021. It's known as the Nolane matter, in which a provisional trial date has been set for January 2023. In the other matter, it's a matter of S versus MP Tabete and 27 others. Park Road, case number 200/7 of 2017. It is the Estina matter. The Gupta brothers have already been charged and warrants were issued against both of them. On 18 July 2022, a request was received from the National Director of Public Prosecution from the Republic of South Africa for the extradition of the Gupta brothers from the United Arab Emirates to the Republic of the United Arab Emirates to stand trial on charges of fraud, money laundering in terms of Prevention of Organized Crime Act 1998 and corruption, contravention of the Prevention and Combating of Corrupt Activities Act. The request is made in accordance with the extradition treaty between South Africa and the UAE, as well as the United Nations Conventions Against Corruption, which is a multilateral international convention to which both countries are member states. We can confirm that the extradition request has been duly submitted to the United Arab Emirates Central Authority today. And we can also confirm that this is within the 60 days period within which the Republic of South Africa was expected to submit the request in terms of the treaty. The second matter is the matter of Mr. Shipiloro Gama, well known as Shepherd Huxley Bushiri and Mary Bushiri. During November 2020, a request was received by the department from the National Director of Public Prosecutions for the extradition of Shipiloro Gama and his wife, Mary Gama, from the Republic of Malawi to the Republic of South Africa to stand trial on various charges. The request was subsequently delivered at the office of the Attorney General in Malawi on 5 December 2020. The extradition hearing proceeded in the Lilongwe Magistrate Court in Malawi. On 19 April 2021, the attorneys acting on behalf of the Bushiri argued in the court that South Africa could not rely on the SABC protocol on extradition, as the protocol has not been domesticated in accordance with Section 211 of the Republic of Malawi's Constitution. The court ruled that even though the protocol had not yet been domesticated, the Malawi Extradition Act clearly demonstrates in the first schedule to that act that South Africa is a designated country for the purpose of extradition, and therefore ruled in favor of the prosecution. The matter was then postponed to Friday, 4 June 2021, for the extradition hearing to start. During the proceedings, the defense argued that the witnesses who will testify against Mr. Gama and his wife in South Africa should travel to Malawi to give evidence during the extradition proceedings. The magistrate court ruled in favor of the defense that the witnesses should travel to Malawi. The DPP in Malawi advised the department that they are of the view that the magistrate court misdirected itself as regards the amounts to a preliminary inquiry, and that Section 9 of the Extradition Act of Malawi never envisaged physical presence of witnesses in court during an extradition hearing. The Office of the DPP in Malawi filed a review application to review and set aside the magistrate court's ruling. The review application was heard on 21 July 2021. The DPP in Malawi indicated that judgment was delivered on 8 February 2022. The court ruled in favor of the presiding magistrate, and indicated that extradition hearing in Malawi will be heard in the same fashion as a criminal trial, and that evidence may be heard in a form of sworn affidavits or by way of a virtual or physical testimony. In that regard, the DPP in Malawi indicated that they will inform the NPA in South Africa when witnesses' statements or virtual testimony will be necessary. On 17 June 2022, the Chief Resident Magistrate Court sitting in Lilongwe heard the state's application for an order of the court to refer the matter to the High Court, where the state seeks to ask the High Court the witness dispositions on behalf of the Republic of South Africa must be made before a competent court in South Africa. Judgment is reserved for the 5th of August 2022 in this matter. The matter of Mr. Marine Brain de Klerk, the Republic of Namibia. On the 15th October 2021, the department received a note verbal from the Minister of Justice in Namibia containing a request for the extradition of Mr. de Klerk. The Office of the Prosecutor General in Namibia is requesting the extradition of Mr. de Klerk from South Africa to the Republic of Namibia to stand trial on charges of racketeering, conspiracy to commit an offense, fraud, theft, money laundering and acquisition, possession or use of proceeds of unlawful activities. The request was forwarded to Interpol and the NPA for execution. Interpol applied for a warrant of arrest. His current whereabouts are being tracked by the investigating officer. The Neo-Black Movement NBM matter with the United States of America. The Department of International Relations and Cooperation, DECO, forwarded a note verbal and attached here to a request for the extradition of Prince Bush Mark, Doris Seju, Gabriel Otubu, and various other syndicates members from the Republic of South Africa to the United States of America to stand trial on charges of contraventions of Title 18, Section 1028A and 2, aggravated identity theft, Section 1343, wire fraud, Section 1349, conspiracy to commit wire fraud, and Section 1956H, conspiracy to commit money laundering of the United States Criminal Code. Investigations in the United States of America revealed that the accused are Nigerian citizens and members of the Neo-Black Movement, a criminal organization which committed the offenses of internet fraud and money laundering since 2011. One of the cells of the organization is based in South Africa and Cape Town. The American authorities over that NBM uses various online identities to further illegal internet-based schemes such as romance schemes, scams, advance fee scams, and business email compromises. Collecting these fraud schemes to NBM have resulted over $6.8 million in losses to American citizens. The suspects were arrested in a sting operation earlier this year and appeared before the Cape Town Magistrate Court. The extradition hearing has not yet started as the suspects are currently applying for bail, which is being opposed by the National Prosecuting Authority. Matters related to the Gusile Power Project and the United States of America. A request for mutual legal assistance was received from the United States relating to allegations of fraud and corruption during the awarding of certain tenders and improper payments made with regards to Gusile Power Plant. During July 2020, the requested assistance was approved and the request was referred to the NPA and Interpol to assist. The NPA and the SAPS are currently conducting investigations. PRASA and the Spain locomotives. The matter relates to alleged corruption by Mr. Makensa Mabunda and others acting on behalf of PRASA in the supply of locomotive by a Spanish company, Foslo Espansao. I hope I have pronounced it correctly in Spanish. On 9 March 2022, a request for mutual legal assistance was received from Spain, and on 11 April 2022, the NPA and Interpol assist with the gathering of the evidence. On 10 May 2022, the Magistrate Pretoria was appointed to assist with the request. Currently, a court date is awaited from the office of the DPP Pretoria to finalize the matter. A matter that involves Mr. Kercher and the Czech Republic. During June 2002, the department received a request for the extradition of Mr. Kercher from Czech Republic. The Czech authorities are requesting Mr. Kercher's extradition to stand trial on several courts on the following charges: conspiracy, 4 charges of fraud, murder, counterfeiting money, tax evasion, unlawful possessions of firearms, credit fraud, kidnapping, blackmail and abuse of information in commercial transactions. On 16 March 2018, the magistrate found Mr. Kercher to be extraditable to the Czech Republic. Mr. Kercher is also currently standing trial in the High Court in South Africa, Gauteng Local Division, on the following charges: conspiracy to murder, 2 charges of unlawful possessions of firearm and ammunition, robbery and assault. Mr. Kercher will also stand trial in the Regional Court on the following charges: conspiracy to escape, corruption, unlawful possessions and firearm and ammunition. The case, which is on the roll, will only proceed once the above-mentioned High Court case has been finalized. There are further criminal cases pending before South African courts involving Mr. Kercher, which are not yet finalized. So this is a matter which is still under development. Mr. Fredendal, Australia. During December 2016, the department received the request for the extradition of Mr. Fredendal. The Australian authorities are requesting Mr. Fredendal extradition to stand trial on the following charges: 5 charges of persistent sexual exploitation of child, 4 charges of unlawful sexual intercourse, 15 charges of indecent assault. At the time the request was received, Mr. Fredendal, a citizen of Australia, was serving a sentence of 5 years imprisonment imposed by the Cape Town Regional Court upon conviction of sexual offences committed against children. Mr. Fredendal was sentenced during April 2015. During February 2016, the parole board found Mr. Fredendal eligible to be released on parole under correctional supervision. However, Mr. Fredendal was not released, as a warrant for his detention was obtained after receipt of the request for his extradition. Mr. Fredendal has since completed his sentence on 7 April 2020. An extradition inquiry proceeded in the Wynberg Magistrate Court on 4 October 2017. On the same day, the magistrate found Mr. Fredendal liable to be surrendered. During November 2017, Mr. Fredendal lodged an appeal against the magistrate finding. During June 2018, Mr. Fredendal legal representatives forwarded representations in the form of a letter to the minister, where the minister was requested not to surrender Mr. Fredendal. However, Mr. Fredendal's legal representative has been informed that the representations cannot be considered until the appeal has been finalized. During September 2018, Mr. Fredendal withdrew his appeal. After a follow-up during October 2018, Mr. Fredendal's legal representation informed the Central Authority that the above-mentioned letter is still relied on and that additional information will be forwarded. After a request by the Central Authority that additional information be provided, documentation regarding Mr. Fredendal's health and a petition signed by the members of the United Mission Church in Cape Town were forwarded to the Central Authority on 16 April 2019. The Australian Central Authority informed South African Central Authority that the prison health services will be responsible for Mr. Fredendal's health care and that they will be able to manage his conditions. This was confirmed by a doctor. In the affidavit by the senior prosecutor, the delay in Mr. Fredendal's prosecution was explained. In the affidavit by the detective, it was stated that the witnesses were still available. On 27 April 2020, the Minister issued an order in terms of Section 11A of the Extradition Act for the surrender of Mr. Fredendall to the Republic of Australia. Mr. Fredendall then lodged a High Court application considering of Part A and Part B of the application. And in Part A of the application, Mr. Fredendall sought an order that he be released pending the hearing of Part B of the application due to his health conditions. In Part B, an order is sought that the surrender order issued by the Minister be reviewed and set aside. The application is being opposed, and the State Attorney will liaise with Mr. Fredendall's attorneys to obtain a court date for Part B of the application to be heard. Mr. Koevenhoven, the Republic of Netherlands. On 7 July 2017, the Central Authority received a request from the Netherlands for the extradition of Mr. Koevenhoven to the Dutch authorities. Mr. Koevenhoven's extradition to serve a term of 19 years imprisonment imposed upon conviction on 3 charges of contravening Article 8 of the War Crimes Act and 2 charges of contravening the Sanctions Act of 1977. The offences were committed in Liberia during a war which took place from 1997 until 2003. Mr. Koevenhoven provided Mr. Chase Taylor with weapons and ammunition, a camp for the storage and distribution of the weapons and ammunition, and assisted Mr. Taylor's troops by arming his own employees. The Netherlands exercised jurisdictions over the offences of Mr. Koevenhoven as a Dutch citizen. Mr. Koevenhoven was arrested on 8 December 2017 and appeared in the Cape Town Magistrate Court and was granted bail on 9 December 2017. On 18 December 2017, the Central Authority received an amended request for the extradition from the Netherlands. Various litigation cases were brought by Mr. Koevenhoven, which resulted in a prolonged delays to finalize the matter. During March 2022, Dutch authorities informed us that Mr. Koevenhoven applied for clemency in the Netherlands based in his poor health. Due to an error, he was granted postponement of the execution of his sentence. This was revoked by his lawyers and are requesting the Dutch authorities to reinstate postponement of his sentence. Mr. Koevenhoven had until 6 May to file documents regarding the clemency to the Magistrate Court Cape Town, which he did. Mr. Koevenhoven then brought an application to obtain copies of communication pertaining to the clemency issue from the NPA in terms of the PAIA Act. The application is being opposed by the department and the NPA. Mr. Chang, the former finance minister of Mozambique, and the Republic of Mozambique, the United States of America. On 17 August 2021, a decision was taken to extradite Mr. Chang to the Republic of Mozambique by myself as the Minister of Justice. The Forum de Monitoria de Osmento, I hope this is proper Portuguese, brought an application to review and set aside the Minister's order. The matter was heard, and on 9 November 2021, Judge Victor gave an order setting aside our decision and substituting it with an order that Mr. Chang should be extradited to the United States of America. Mozambique then filed an application to the Constitutional Court to appeal the judgment. The Constitutional Court dismissed the application with cost with regards to these matters. It is still in the SCA for argument and also for decision. So that is where the matter is now. A matter related to the Bank of Botswana. A request for mutual legal assistance was received from Botswana relating to an investigation into money laundering and fraud. The requested assistance was approved in September 2020, and the NPA and SAPS conducted investigations. However, the Republic of Botswana through AfriForum brought an application for a mandamande fanspole for the minister to approve the request for mutual legal assistance, even though the request had already been approved. On 7 July 2021, a draft order was granted by the court in favor of the Republic of Botswana, we brought an application to rescind the order in May 2022, and the court did not make a judgment and requested that the parties meet to resolve the matter out of court. On 4 April 2022, all the evidence was hand-delivered to DERCO, and on 1 June 2022, DERCO delivered the evidence to the High Commissioner of Botswana. For the purpose of central authority, the matter has been finalized. And you will note that in all the extradition matters are matters between the two, the requester and the requesting state. This one is a bit unique because of intervention of a party which is not a state player. Mr. Bobrov and Israel. In March 2017, an Israel police investigation was initiated after freezing assets based on suspicious transactions by the suspect, Mr. Darren Bobrov. The Israel money laundering investigation suspected that the funds were proceeds of offenses that Mr. Bobrov and his father, Ronald, had allegedly committed in South Africa. Therefore, on May 8, 2017, Israel sent South Africa a request for legal assistance to provide information concerning the South African investigation. Israel also requested that South Africa send a request for legal assistance to seize the assets on South Africa's behalf for their investigations. Unfortunately, it was determined investigative avenue was not viable, since it was not possible to establish a link between said assets and the offenses allegedly committed by Bobrov in South Africa. Consequently, Israel was unable to execute South Africa's request for legal assistance due to the inability to link the assets to the South African investigation. The seized assets were at immediate risk of being released. As such, in January 2019, Israel sent a delegation to South Africa after a productive meeting with the South African counterparts. Israel was able to build a domestic money laundering investigation against Mr. Bobrov regarding offenses that Bobrov perpetrated towards the Israel banks. In the context of this domestic investigation, South Africa provided important legal assistance, in particular the provision of vital affidavit by SARS representatives. A civil forfeiture proceeding was also initiated by the Israel prosecution based on the same Israel domestic offenses. In the context of the civil forfeiture proceedings, the Israel authorities recently entered a settlement with Mr. Bobrov, considering a wide array of factors. The settlement included the closing of the criminal file against Bobrov and the forfeiture of funds that were seized in Israel in the civil forfeiture and criminal proceedings. In recognition of the important assistance provided by South African authorities and law enforcement in the Israel investigation, the State of Israel proposes sharing of the total amount of 3 million NIS with the government of South Africa. On 19 May 2021, the Asset Forfeiture Unit at the NPA corresponded with their counterparts in Israel regarding the transfer of the funds to South Africa. On 26 May 2021, the attorneys representing Bobrovs in South Africa indicated to the NPA that they intend to petition the Constitutional Court to stop the process. Pleadings are currently being exchanged and the court date is yet to be determined. The Noordeer matter, Namibia, known here in South Africa as the matter related to Palapala. The request which the Department of Justice and Constitutional Development received from the Republic of Namibia did not specifically in relation to Mr. David Emanuela, only as intimidated by our sister nation's police force. It is not correct that there was no response from South Africa on the request of mutual legal assistance in the case involving Mr. David Emanuela. The Central Authority of the Republic of South Africa has transmitted correspondence through diplomatic channels to set the record straight with the Namibian authorities. During September 2020, the Department of International Relations and Cooperation forwarded a note verbal from the High Commissioner from the Republic of Namibia and attached thereto a request for mutual legal assistance dated 13 August 2020 by the authorities in Namibia to the Department of Justice in South Africa. In the request, the authorities in Namibia requested assistance from South Africa in a criminal investigation relating to the contravention of Section 456 of the Prevention of Organized Crime Act 2004 of Namibia. The request was first referred to the Special Commercial Crimes Unit of the National Prosecuting Authority to ensure that the request does not involve foreign bribery, as South Africa acceded to the OECD Organization for Economic Cooperation and Development Convention Against Bribery of Public Officials in International Business Transactions, the Bribery Convention, during 2007. The request was thereafter returned to the department by the SSSU with the recommendation that the request be processed. The matter was allocated to an official within the Chief Directorate, International Legal Relations, to process the request. The request was perused and found that it did not comply with the provisions of International Cooperation in Criminal Matters Act of 1996. The request could therefore not be processed at that stage. The request was returned to DERCO on 18 May 2021, accompanied by a letter indicating to the authorities in Namibia how the request should be amended to enable South Africa to render the necessary assistance. On 31 August 2021, DERCO sent an electronic note verbal to the High Commissioner of the Republic of Namibia, highlighting the feedback from the department and requesting the authorities to amend the request. On 1 September 2021, the High Commissioner of the Republic of Namibia acknowledged receipt of the note verbal. Since then, the authorities in Namibia have not sent an amended request back to the Republic of South Africa. The Chief Directorate International Relations and Legal was previously requested to confirm whether a request for mutual legal assistance relating to Mr. David Emanuela had been received from the authorities in Namibia. As per the press statement, the request could not be located as the file was opened under a different name. The request related to an investigation of docket Nordever CR 14 June of 2020, in which Mr. David was one of the three suspects. The other two suspects are Messias Petras Afrikaner and Eric Chikango. So because of this name, the request could not be located by the officials. On 16 June 2022, the Inspector General of the Namibian Police Force released a press statement which detailed, amongst others, a meeting between the police authorities of South Africa and Namibia, where a certain operational information was allegedly shared on Mr. David and other Namibian nationals suspected of having stolen money from South Africa and fled to Namibia. And it is then that we received lots of questions. The Central Authority received lots of questions about this matter. And as I've said, it could not be located at the time because the name in which it was registered in the department is different from the one that appeared in the press release. At this point, the Central Authority is still awaiting the amended request from the authorities in Namibia. Thank you very much.
Thank you, Minister. Good afternoon, Minister Lamola, DG of Justice, Advocate Mashabane, members of the media, ladies and gentlemen. I'm not going to go through all of the matters that the Central Authority, the Minister, has decided to detail, but we're going to deal with just the one matter, and that is the submission of a formal application request for the extradition of Mr. Atul Kumar Gupta and Mr. Rajesh Kumar Gupta. I can confirm, as the Minister has just said, that today, Monday the 25th of July 2022, a formal extradition application was submitted to the Central Authority in the United Arab Emirates. This is well within the 60-day period from the date of arrest of the Gupta Brothers, as set out in the extradition treaty between South Africa and the UAE. The deadline for submission is the 2nd of August 2022. The application was submitted both in English and Arabic, and it addresses the general requirements for extradition, which, if met, would allow the extradition to be granted under either the existing extradition treaty with the UAE or the United Nations Convention Against Corruption, UNCAC, or both. A multidisciplinary team within the NPA led the legal aspect of the process and worked in a focused and well-coordinated manner with the Office of the DG of the Department of Justice and Constitutional Development, who, as you know, are designated as the central authority for extradition processes. And so they worked together to prepare and finalize the application. This work included consultation with legal counsel and some team members meeting their counterparts in the UAE early this month to ensure that the request for extradition met all the requirements of the bilateral treaty, that it was in accordance with the UAE domestic laws and requirements, and to build trust with relevant law enforcement partners. The NPA team, in close collaboration with the Office of the Central Authority, the Director General of Justice, worked relentlessly on complying with legal requirements of the extradition treaty and UNCAC. Political considerations regarding the extradition process were left fully in the hands of our partners in the Ministry of Justice and also the Department of International Relations and Corporations, DIRCO. The submission of the formal application request for the arrest and extradition of the Gupta brothers is an important milestone in the NPA's commitment to hold accountable perpetrators of state capture and to uphold the rule of law. It reaffirms our resolve to be the lawyers for the people and to seek collective justice for our country. As this process unfolds and the extradition application is heard in the UAE courts, the NPA will continue to collaborate and support its counterparts in the UAE to ensure that we do all that is necessary to have the Gupta brothers extradited and to face justice in South Africa. We must commend the UAE authorities for their cooperation during this process. Whereas this process could take several months, as the NPA, we will continue with our commitment to deliver justice for impact. The country demands this of us, and we are ready to keep moving to bring justice. Thank you.
Thank you very much, NDPP and Minister. Colleagues, we'll now open for a round of questions. We'll start with our colleagues who are in the press room with us here. We'll take 5 hands and we'll note all of your questions, and then Minister will be assisted to respond to the questions by the Central Authority, the Director General, where possible. Okay, let's start at the back. Nkosikona Duma, sister from SABC, Erin and Karen, in that order.
Good afternoon, Minister. My name is Spokesperson. I'm from IUS. I just have one question, and it has to do with the Gupta Brothers. The Director of Public Prosecution has just said that the process for extradition could take several months. Perhaps could we get some clarity as to how many months are we looking at, and also what would be happening in the interim before we hear an outcome of the extradition application?
So just how long it will take?
No, yes, yes.
And
The process is in the interim while we wait. What should happen?
okay, thank you.
My name is Lonsama Seko from BBC News. Minister, I'd like to know, it is expected that the Guptas are going to fight this extradition, and they are possibly going to claim hardship if they are jailed in South Africa. And given the reputation that South African prisons have internationally, how will you ensure that they are successfully brought into the country to face justice? And secondly, What is the current state of the Guptas where they're concerned? We understand that they have been remanded in local custody in the UAE after they were transferred from police cells. What I would like to know is, did they apply for bail in the interim in the UAE, and was it denied, as far as you know?
Okay, so there are 3 questions there. We'll just highlight them again for us.
So it would be, given the reputation that South African prisons have internationally, case in point, Trend 1, what is it that the South African government is going to do to ensure that the Guptas are successfully brought into the country? Secondly, it's about what the process is now with the Guptas. Are they in prison cells in the UAE? Did they apply for bail? Was it denied?
Okay, so it's prison conditions, and have they applied for bail? What is their current status? Erin and Karen.
Thank you. You bumped me up. I think Karen was actually before me, but she's kindly agreed to let me go first. Afternoon, thanks very much for the update. Erin Bates here from Business Day. My first question for the NDPP, when will the extradition matter be heard in the UAE? Do we have any indication? Secondly, who's on the National Prosecuting Authorities Council team for this? Obviously, it's a very high-profile matter of great interest to the public, and I think it would give us a lot of confidence to know who you have assigned to the matter. And then Salim Essa, we know, has been sanctioned by both authorities in the UK and the US. There is a plethora of evidence against him in the Zondo Commission's findings and also its body of evidence for its work. Is there any effort to try and have him extradited too, and are you working on a case against him? And then finally, you have promised the country, I think it's 9 seminal cases on state capture by September. Could you please just provide an update on how many of the 9 are currently underway and how many are still pending? Thank you.
Colleagues, just a word of advice, really pick your questions. Don't throw a shopping list at the colleagues at the NDPP and the Minister, because I think some of the questions you ask are important, but if we throw a shopping list at them, then some of these things will be missed. So, okay, Karen.
Okay. Sorry, my question is for the NDPP. The statement says that the Guptas, as I understand it, are being extradited for both New Lane and Estina. But as far as I know, the Estina matter that is in court against Tabete makes no mention of the Gupta brothers. Given that the extradition agreement with the UAE explicitly states that these have to be matters that are before the courts and people have to be charged, can you please provide us with the charge sheet and the further particulars in that matter? And then just in relation to the process itself, are you confident that if you do get an extradition from the UAE authorities, because they seem extremely positive, there seems to be massive political will from them in regards to this, that the NPA will be able to mount a case that results in their conviction? Because as I'm sure you're aware, in the New Lane matter, which is currently before the courts, their lawyers are saying that the case against them is non-existent, and they're actually bringing litigation to have it thrown out. So if that happens, what will the implications be for the NPA? And then lastly, in the New Lane matter, when the NPA sought red notices, they sought them for the Gupta's wives as well, on the basis that they were directors of Island Site. And Island Site, of course, is a pivotal accused in this matter. Have you abandoned efforts to seek the extradition of the wives? Because the case materially against the wives is very much the same case that is made against the husbands. And, you know, what are the implications should you not pursue the wives for New Lane? Thank you.
Mr. Jones, I saw your hand come up last from ENC.
One question. Excuse me, guys. Minister, Poleli Jones from ENC. Let me just an update on the Bushiri matter as well. I've been following the case very closely, and the last time I checked, when I spoke to some of the families of the witnesses, they actually refused that they daughters allegedly implicated in this matter be taken to Malawi to testify. And it seems as though it's becoming complex by matter again, because his legal team at some point were also arguing that there weren't proper papers filed from the Correctional Services Department this side, or the Justice Department. So maybe just an update on that with the status as to how far it is. Thank you.
Pule, specify what exactly is your question?
Update.
But we provided that update in the statement.
No, but there seems to be confusion because the legal team are arguing that the department this side hasn't filed proper papers, and there's also another matter with the witnesses having to go to Malawi as well.
Okay.
Maybe the names confused.
Yeah, Shipiliro Gama. Oh, okay. Okay, we've heard all the questions. I think NDPP, if you are ready, you can come, followed by the central authority if there's anything that you'd like to clarify, and then the minister.
Do these ones work here? Should I come there? Oh, okay. Okay, thank you very much. The first one with regard to, oh, I think I need that file, please, of some information. Let me leave that one for later. The issue of, when will the matter be heard and some of the processes that would unfold. What we can say in that regard is that the matter will be placed before what is referred to as an appeal court in the UAE. We advise that the judges actually work on a checklist and look to ensure that we've complied. The requesting state complies with all the requirements. In approximately 30 days after this appeal court procedure, the matter is then taken to a Supreme Court, and thereafter the Attorney General will submit the matter to the Minister of Justice in the UAE for the final decision. So, we cannot give exact timeline. That's about as far as we can go. But we understand that it could take a couple of months to finalize. In terms of the issue of bail, we understand that there were applications that were denied. With regard to the issue of who is on the team, I'm not prepared to mention the names of the prosecutors and investigators on the team, obviously for security reasons, but we did engage in the early stages with external counsel as well, and that was widely reported on. With regard to the issue of one of the suspects, I'm actually loath to mention the names of people, but of course they mentioned in the Zondo Commission reports. There's a lot of public information about numerous suspects, but our approach is that we do not mention suspects until people appear in court. All I can say is that with regard to many people that have been mentioned, and some that haven't even been mentioned, the NPA is looking at, has organized itself after when the first Zondo Commission report was made public, and subsequently we've organized ourselves. We set up what we refer to as a task force internally, and also with members of the DPCI, and to the extent necessary SARS, and we've looked at many of the cases that have been mentioned in the reports. We've prioritized them, and we are looking at a whole range of information and evidence that they may be available against many suspects. And once we go through this process, once we apply our own independent investigation, once we are certain that we actually meet the standard of a reasonable prospects of a successful prosecution, we will then proceed to charge people, and also, if it's necessary, to make applications for others to be extradited, we will deal with that as well. With regard to the two matters that have been mentioned, we are confident that we have evidence. Well, Nulane is in court, but we certainly have evidence in the other matter that would actually meet the standard of reasonable prospects of a successful prosecution, and those documents are being finalized as we speak. The question of whether we will be confident that if we do get extradition, if the Gupta brothers are extradited, whether we will be able to mount a case that leads to a conviction, what I want to assure the people of South Africa is that as the NPA, we do not bring cases unless we ourselves are satisfied that it meets the standard of a reasonable prospects of a successful prosecution. That is a standard that is required in terms of our policy, and we will only charge people if that standard is met. At the end of the day, whether there's a conviction or not depends on a whole range of reasons. And so, we cannot guarantee, of course, that there will be a conviction. But what we can guarantee is that as the prosecuting authority, we will do everything possible to ensure that the prospects of a successful prosecution and a conviction is extremely high. And so, hopefully that, that's as far as we can take it. With regard to the one particular case where lawyers are saying that the case is non-existent, that's understandable. That is the role of some defense lawyers, to try to create the impression that there's no case. But we expect that. And as long as we know in the NPA that we meet that standard, we cannot be sidetracked by comments that are made by defense lawyers, and we will also not be drawn into litigating matters in the public space. And so often when these comments are made, you'll find that the NPA is not responding. It's not because we can't respond. It's because we will simply not be drawn into, as I say, litigation in the public space. With regard to the wives of the two Gupta brothers, that matter is under consideration by the ID. I think there's one other question, but I'm going to hand over to the ID, to the Minister, and then come back with the one question, because I just want to find the information. Thank you, Minister.
Thank you very much, Chris, Minister and DPP. There's a question that there's a gentleman who asked the last question about the Bushiri matter, that as far as you know, they are saying papers are not in order. That's not true. That's not the issue before the court. The issue before the court currently is about South African witnesses, whether they should travel to Malawi to testify or make disposition from here. So what the NDPP in Malawi did on our behalf is to make an application to have the matter moved from the magistrate court to High Court, so that they can make an application that witnesses in South Africa don't have to travel to Malawi to testify on the extradition proceedings. They can make statements here in a competent South African court or testify virtually if needs be. So the question of the filing of the papers is not an issue. Papers are in order. I needed to clarify that. Thank you very much.
Yeah, no, thank you. With regards to the prison conditions, which is the question asked, is that we handle inmates in terms of the Correctional Services Act, and as the South African government, we subscribe to the Nelson Mandela rules, which is the international standards for keeping prisoners in any country. So we are international compliant in terms of the UN conventions, and our facilities are of a standard that is universally accepted. The standard of any prison is guided by the Nelson Mandela rules, as I've said, which were adopted by the United Nations. So they are of a condition that is in terms of the rules. The issues that you are raising, obviously from time to time they will arise, issues of overcrowding and all the issues that affect prisons, but those are consequence and come as a result of us handling inmates in terms of the standards that we're expected to handle them. From time to time, those challenges will arise, but we handle them, we deal with them, and our prisons are compliant with the international standards. So we are convinced that there will be no case on the basis of the conditions of our prisons. Across the globe, the standards we're applying are the standards that are applied across the globe. I think the other issue that was raised is the issue of the political will in terms of the executive to handle the matter. From our side, you have seen there is commitment, and we are convinced that there is also a political will to attend to the matter, even in the UAE. We have not seen anything since the signing of the treaty between the UAE and South Africa. We've seen cooperation, and including the ambassador of the UAE here in South Africa, we have received very good cooperation, and even our ambassador of South Africa in the UAE, he has also told us that he is receiving very good cooperation from the authorities in the UAE, and I think that is the reason why he could also facilitate the meetings that the NPP spoke about between the prosecutors of the two sovereign states, to be able to meet, to deal with technical issues, and it's because of that diplomatic, mutual friendly relations between the two countries. Thank you.
Okay, we will note your follow-up questions, but maybe let's also take some of the questions of the colleagues online, just so that we don't have an overlap of questions. Vanessa, can't see you. Yeah. If you can just read out the questions for us that have not been answered yet, but the questions that have been answered, please do not refer to that. The colleagues do know exactly which questions have been answered already.
Okay. This is a question from Kaukelo at UFM. He has two actually. Other than the request from the Namibian authorities, how much did the minister know about the Phala saga, particularly the actions that followed, such as the hunting down of the alleged robbers? His second question is, how concerned is the NPA about perceptions of a cover-up in the handling of Phala, particularly because of the lack of feedback from law enforcement agencies after cases were lodged? Only the public protector has been transparent.
Just read them again, just so that ministers are clear. Sorry.
Other than the request from the Namibian authorities, how much did the minister know about the Phala saga, particularly the actions that followed, such as the hunting down of the alleged robbers? The second question is, how concerned is the NPA about perceptions of a cover-up in the handling of the Phala issue, particularly because of the lack of feedback from law enforcement agencies after cases were lodged? Only the public protector has been transparent.
Okay. Then before you come, Minister, there's also a question in DPP. The colleagues are saying specifically, are the Guptas in custody? I know you've said that they've not been granted bail, but colleagues want to hear something else, so we can update them on that. Yeah. And then maybe I can then take the moment to then take the follow-up questions in the room.
Thank you. Just one, promise. It's 53 days since the Guptas were arrested, so we're on the tail end of that 60-day window. Is this not an indication of being on the back foot? Because despite these very friendly and warm discussions between the two countries, it seems to have taken quite a while to actually act on the arrest. And obviously, time is of the essence, as the idiom goes. Why has it taken up to this point to get everything together when you knew, for example, that documents ideally need to be in Arabic? There'd been discussions about the legal processes. Minister, you yourself spoke about the fact that there are different legislative frameworks in different countries. It could be a concern for those of us who are watching this. And then just in terms of the Phala matter, if Minister, you could just clarify in very clear terms what the point is that you wanted to highlight today around the paperwork back and forth on extradition. I'm not sure it came through quite clearly, at least for me. Thank you.
Yeah.
Sure, just for 2 follow-ups for Lady Treaty Jones again. I just wanted to ask something in regards to the Bushiri matter. Maybe just an update on this one again. Are you positive with the extradition process thus far? Do you think as though you are on the winning side in terms of ensuring there's accountability? And maybe just with the Minister Manual Change extradition process, perhaps maybe I missed this, but how soon will this matter be wrapped up as well? Thanks.
Hi, I have a follow-up for Advocate Batoy. Under the terms of the UAE South Africa extradition agreement, it says the parties agree to extradite each other pursuant to the provisions of this treaty, etc., etc. Persons whom the authority in the requesting party have charged with or convicted of an extraditable offence. The treaty also demands that in circumstances of a person accused of an offence, the requester shall be accompanied by an original certified true copy of the warrant of arrest and the charging document issued in the requesting party where the request is emanated from. So I'm just curious, in circumstances, because it does appear that while the NPA may have the intention to charge the Guptas in relation to Estina, you haven't actually done so. Is that not a concern? Because the provisions of this treaty make it explicitly clear that you can't charge on case, you can't seek extraditions on matters that you haven't charged people with. Thanks.
Okay, NDPP, whilst you write that down, there's another question in our media WhatsApp group. Maybe this can be for the Central Authority directly. Is there an extradition request in relation to President Kama? And then there's another question as well on the security concerns, NDPP. This is from Amanda Watson. And she's saying, what are the security concerns around the team assigned to the Gupta extradition? Have they been threatened, and by whom? Okay. Yeah, maybe DG.
Okay, thank you very much. Let me start with the Phala Phala matter. I think one part of it is what did the minister know? Now, as we have explained, that the request was made by the central authorities in Namibia, but from our side, as the central authority, we found it not to be in order, and we took it back through the diplomatic processes for them to address issues that were lacking in the request, which at the time as well, it was under different names. There was no David Emanuela as part of the request. So Minister ordinarily will not know about such a request until such time that the central authority is satisfied that the request is in order and meets all the requirements. Then we'll process an internal memorandum to the minister. Without that, then the minister will not know anything about that process. And I think the same will apply to the National Director of Public Prosecution, where you are saying there's transparency from the public protector, and NDPP has not said anything. The NDPP will also get to know once documents are finalized. So when they are at that stage, back and forth between the central authority, the National Director of Public Prosecution will not have a knowledge that there are documents that are not in order that the Central Authority of South Africa has returned back to Namibia. So I think that should be the understanding. And what was the point of this briefing? I thought it's a matter of interest because you remember that we make reference to the fact that our counterparts in Namibia had issued a statement that they had made a request to us and we never responded, and that was the reason why they released the suspects. And that's the information that the South African public has. So we needed to clarify this. And that's why Minister mentioned the fact that as central authority, we have written a letter to our colleagues and counterparts in Namibia, putting it on record that it is not true that the matter is sitting with us. It is back in their court because we wrote back raising the matters, and we even reminded them and said, by the way, we wrote back to you seeking more information on this matter. Yes, the issue of the names, that's what I was talking about. That, by the way, that request didn't have any Emanuela that is mentioned as the key player in the so-called Phala Phala saga. It was different names altogether. But still in those different names, there was a processing which indicated that the documents were not in order. And the Emmanuel Chang, after the High Court judgment, which reversed the minister's decision, and that Chang must be sent to the US, the Mozambican government appealed that decision. I think they filed applications both to the Constitutional Court and the Supreme Court of Appeal. And you know, last month the Concord dismissed the matter. They did not admit it. So what is left now is for the Supreme Court of Appeal to set a date for a hearing for the appeal. So that's where it is until the Supreme Court of Appeal takes a decision on that appeal. It means there's not much that can happen. Lastly, an extradition request for President Kumar, we have not yet received it. So we don't have it. Thank you very much.
Thank you. Before I get to the specific of the 9 seminal cases that we mentioned, just to mention some of the figures from our annual report from last year. They were with regard to anti-corruption cases. There were 380 cases that were finalized in the Specialized Commercial Crime Unit, the courts, with a verdict, with a 90.5% conviction rate, which was 73 more than the previous year. With regard to the ID, there are 26 cases on the roll, 20 criminal and 6 civil. Well, this was at the time of the annual report. And the ID had restraining orders valued at over 6 billion. There were 380 government officials convicted for corruption and related offenses. 209 persons convicted of private sector corruption. With regard to money laundering cases, 86 were finalized with a verdict. With regard to asset forfeiture, there are 370 completed confiscation and forfeiture orders, estimated value at 406 million, and the number of freezing orders estimated at 5.5 billion. We accept that there's a lot more work to do, and we're certainly working very, very hard on this. We are ensuring that all the cases have the necessary resources. We've had good support from the Department of Justice. We're working very, very well. The ID is working extremely well now with relevant stakeholders. So this enhanced collaboration and ensuring that there's sufficient but also dedicated resources with regard to the matters particularly emanating from state capture reports, and also those not mentioned there. So that is critical in the sense of dedicated resources in the ID space, in the DPCI space, as well as in the Specialized Commercial Crime Unit space, as well as asset forfeiture in the NPA. And so dealing specifically with we've mentioned 9 seminal cases. Some of them have already been enrolled. Let me just get those. I think there's 3 that have been, some have been enrolled. State versus Kuben Mudli matter, the Transnet former executive. Well, that's going to be in court on the 29th of August. State versus Ronika Raghavan and others in the Tegeta and Optimum coal mine matter, the rehab matter, in the Johannesburg High Court on the 1st of November 2022, and State versus Mohideen and others, which is an ABB matter, which is back in Randburg Magistrates Court on the 14th of October. So some matters have already been enrolled. I have every confidence that we are well on track to enroll not just the 9 seminal cases we've mentioned, but also many others that will be impactful cases both in the ID space as well as in the DPCI SCCU space, as well as asset recovery. With regard to I should mention, I was, sorry, this question on being on the back foot, having submitted the papers 1 week before the deadline. This is hardly being on the back foot. It's really, we could have submitted on the last day. That would be on the back foot. The fact that we've submitted early gives us time to deal with it if there are any issues. And as I said, with the good working relationship we've had with the UAE, we think that we have sufficient time in the unlikely event, because as the Minister had said, there's already been collaboration and we're quite confident that our papers are in order. In fact, there was, if you look at the whole process, we were, one might think 60 days is a long time, but it's really not a long time. It's really a very, very short space of time. And so we needed to ensure many things, including that we had an A-team within the NPA and also engaging with senior counsel externally to ensure that we had our papers drafted in the best possible way. And so we got internal expertise of colleagues that were working in the extradition and the MLA space, including colleagues that had actually just retired, but we brought them back. So we had a team within the NPA was one that had all the necessary expertise to deal with the issues, the important issues with regard to this type of request. And we also engaged with external counsel, as we mentioned. And then in addition to that, once you had the papers, there were various different processes internally to ensure quality control. We then had to make sure that all the documents were translated into Arabic, but they were all they were not sequential. Many of these processes were actually running in parallel to make sure that we actually met the deadline, and we met it well within the deadline that was of 60 days. So we're very confident about the request, about the quality of the request, and now we'll wait for the processes in the UAE to unfold. We also, in this process, as the Minister said, actually engaged with colleagues in the UAE to ensure that we had met all the requirements. Yes, we are well aware of the specificity and speciality clauses in terms of extradition. We are confident that, notwithstanding the fact that Nulane and Estina are the only two matters that are mentioned, we don't want to actually say anything more about this, because this is an issue that will certainly be the subject of possible litigation. But as the NPA, we are quite confident that we'll be able to deal with those issues. In terms of the security concerns, the staff have not been threatened, which is really good, but we're not taking any chances. We know that the risks are high, in the sense that there are many people that will want to ensure that they do not face justice in South Africa. And so we don't want to take any chances and put our people unnecessarily at risk. But for now, nobody's been threatened, but as I said, we're not taking any chances. And I think, Crispin, you clarified the issue about the bail. Okay, so just to I think there was, Crispin advises me that it wasn't clear about whether the Gupta brothers are in custody. They are. Thank you.
Yeah, no, thank you. I think the DG has responded to what I would have known on this Pala matter. I know there is an excitement to presume that there was some kind of a cover-up, either by myself or anyone on this matter. But the DG has explained that how the process works is that it will be the official who received the request who knows in the central authority, and when they have processed, they've dealt with all the administrative issues. It's when a memorandum will then be routed to myself to look at it and approve and whatever that may need to be done. And this matter had not yet reached that stage for a memorandum to be brought to me to sign or to do whatever. And it is the same that he related to with regard to the NDP. They will not have received that request, because there were still issues that the central authority and the Central Authority of Namibia still had to deal with before they could bring the matter to us. So I did not know that there was such a request with regards to this Palapala matter. And as the DG said, that also the how it was phrased in terms of the name, how the file was opened. It was opened as Nordwerk or something. So when the statement was issued, we asked from the department, central authorities and officials, that have you received this request? And they searched everywhere. They said, no, we have not received this type of request. And there were exchanges between the central authority, the DG, DERCO, and Namibian authorities to really understand, indeed, did we really receive this kind of request? It's only when we then got the approval stamp of receipt from DERCO that showed that indeed there was a request that came in. But the request was under this phrasing of Norveg, and there were 3 accused people. And one of the accused people was this Naulan or something, David Emanuela. It's only when then they went back again and checked that they realized that indeed this came through. Then the issue was what then happened when it came through. It was realized that the department responded to the Namibian authorities to say the request has come through on this matter, but it is not in compliance with the Act. And this is how you must make the request compliant with the Act, which there was no response. And again, when that was realized, the DG as the central authority dispatched another note verbal to the Namibian authorities to say, this was our response, that this does not meet the requirements of the Act. We are still awaiting for you to provide us with the one that is compliant. And that is where the matter is. As we speak now, we stand ready to cooperate, to work with our Namibian authorities, because we have always had very good mutual cooperation between the two state sovereign parties. And the request comes from both countries with no difficulty. Even ourselves, when we need help from them, they help us in terms of the agreements, which we think that cooperation, that mutual cooperation, will continue. With regards to the matter of Mr. Shipililo Gama, I think maybe we did refer to it in the statement. Mr. Shipililo Gama is the man well known as Prophet Shopet Bushiri, but his official his names that we have is Mr. Shipililo Gama, well known as Shopet Bushiri. We did update on that, and I think the DG has explained where the matter is. Our papers are compliant. I don't know where does it come from that there is someone who is raising that our papers are not compliant. It's in order. The matters are being ventilated in the courts of Malawi. That is where the matter is now. The courts of Malawi are dealing with the matter, and we are awaiting the outcomes. I think it's the 5th of August. Yeah, that is that's where we are on that matter. Whether there is mutual cooperation between the two sovereign states, South Africa and Malawi, yes, there is. And we also process their requests from time to time. What we have given you here is just a fraction of what we deal with. We deal with a lot of requests and lots of jurisdictions across the globe. And the Malawian authorities up to so far, we have been cooperating with them very well. And I do think that even the courts of Malawi up to so far have handled the matter very well. They've proven their independency. The matter is being ventilated because Malawi is also using our kind of a common law system. And up to so far, we think that the matter is receiving the necessary attention. But that does not take away from the reality that extradition matters, and this cut across, even the one which is in the UAE, can by their very nature be protracted, because there could be protracted legal processes in any extradition matter. If you look at the one of the Netherlands that I gave you an update on, it's a very old matter, since 2002. We are still in court, even now, exchanging documents and all that. So extradition by its nature can be a protracted legal process. But from our side as the central authority, we stand ready to take any legal challenge in any part of the world. And that is what is currently happening in Malawi. And we stand ready with regards to the UAE to take any legal challenge that may arise. We believe that there are grounds in terms of the treaty and in terms of the Extradition Act for us to stand and for our request to withstand any scrutiny in any jurisdiction in the world in line with the United Nations Convention. Thank you.
Thank you. There was a question about any concerns about perceptions of a cover-up with regard to the Pala Pala matter. Just to say on this, the NPA is not involved in the investigations. The DPCI are conducting investigations, and once they reach a point when they feel that the NPA needs to be engaged, they will, and then we will deal with the matter as appropriate at the time. But just to say that this matter will be dealt with like any other matter. The rule of law must prevail in our country no matter what. And so, just dealing with the issue of the Estina, just to complete my response there, warrants of arrest have been issued, but they haven't been executed. So that matter will need to be re-enrolled. With regard to, media engagements by the NPA, I want to say, there seems to be a suggestion that the NPA does not speak to the media often enough. Perhaps the national director does not speak too often, but in many jurisdictions around the world, the prosecuting authority don't speak at all, or they speak in a very limited way. In a sense, I think as the NPA, we have been very transparent, we have been very engaging with the media, we have been open. If the national director doesn't speak, there's many other members of the NPA that talk to the media. If and when there's a need for the national director to speak, like today, we will certainly address the media. But we have so many different initiatives to engage more with the people of South Africa. For example, the DPPs in each of the regions have these media briefings in the particular region dealing with what activities, challenges, progress in various cases, including state capture and other corruption cases in particular regions. We've had civil society engagements. So, we are trying to be as transparent and accountable as possible, and we will continue to do that. It's really important that as the NPA, we are held accountable. But I really want to assure the people of South Africa is that we take our work very seriously. It's been a tough road, but we know what we have to do. And whether it's tomorrow, whether it's 3 months, 4 months, 6 months, a year, if there's evidence and there's a case, we will take decisions to prosecute. The rule of law will be the only thing that guides us in that decision-making process. It doesn't matter who it is. It doesn't matter when it is. We will do what the Constitution requires us to do. Thank you very much.
There's one issue that I forgot to address earlier on, is this issue that as the central authority, we are on a back foot also with the NPA on submission of the extradition request. Is that if a reasonable period of submitting an extradition request in the view of the two central authorities and the two countries was an hour after an arrest or 5 days after an arrest, we will have put it in the treaty. It will have been in the treaty governing South Africa and the UAE that when you want to arrest anyone, there must already be an indictment, a warrant of arrest, the extradition request and papers must be ready. That when this person is arrested, an hour after he is arrested, you must submit the extradition request. I think that is an unreasonable proposition and conclusion, because there was a reason why the 60 days period was put in the extradition treaty, to give both parties an opportunity. You might be having the charges, the indictment ready and everything, but the legal processes of the two countries are different. And when you have got an extradition request in this light, particularly the one that we're dealing with of the UAE, unlike the one in Malawi, by the time the NPA drafted the whatever and the central authority had to request, we knew that Mr. Gama is in Malawi. But this was done in terms of a red notice. These guys could have been arrested anywhere. They could have been arrested in India. They could have been arrested in Kazakhstan. They could have been arrested in the United States of America. They could have been arrested in Zimbabwe or in Mozambique or in Ivory Coast or in France. So we did not know where they are. The red notice was given to all countries in the world which are members of Interpol. While there was some strong belief that they might be in the UAE, but there was no official confirmation that they are in the UAE. And also from time to time there will be rumors that they're in India, there will be rumor that they are in this other country. So we could not work on a rumor and put an interpretation in Arabic on the basis of a rumor. Hence, after the arrest, it is then that you can then translate into whatever language. If they are in France, you can then engage with the French authorities that you have arrested our person. What are the requirements there in France? Here we've got a treaty, we know. But in terms of French interpretation, all those kind of technicalities, it's necessary that the authorities must engage on them. And this is what happened on this matter. The central authority had to engage on the other issues that relates to the treaty and all that. The NPA and their counterparts, the authorities in the UAE, they also had to engage on their issues that relates to what they are dealing with, including the language, Arabic, and all those things. You can't do them in 1 hour or in 5 days. So I think that the proposition is unreasonable. So the 60 days, there is no back foot. And from our side, as the central authority, want to thank the officials who worked on the matter, the officials from Justice, and also the officials from the NPA. And I also want to deal with this notion that we do not have the expertise to handle these extradition things. If you listened to me for that 30 minutes, all those matters are handled by officials from both the NPA and the Department of Justice, internal. We only engage external counsel just to confirm whether we are on the, to also have a second opinion, because you are also dealing with matters of national interest. But the officials in the department have been excellent, who are dealing with these matters, and even from the NPA. They also negotiated the treaty. They negotiated the extradition treaty. They negotiated that process up until we signed. So these are experts in the field. They've been there for many, many years. And they deal with many issues, as I said here. What I gave you is just a fraction of what we deal with, because we believe these are matters of national interest. But there is a lot of matters that on a day-to-day basis we deal with on this aspect. Thank you very much.
Thank you very much, Minister, for those closing remarks. I saw someone on Twitter said, why don't they just use Google Translate? So I think you've really explained the importance of this and how it works. Indeed. So with that said, ladies and gentlemen, I'd like to draw this press conference to a close, and those of us who may want to seek interviews know what the process is. Thank you very much.